321 on the Scott Show. North Carolina is suing the federal government after the DOJ tried to make the state kill its so-called transgender bathroom law. Fox News Sunday reported that the federal government is acting like a bully. According to the governor, Roy McCrory, he insists the law only pertains to government offices, universities, roadside rest stops, and would not impact private businesses. This lawsuit asking for injunctive relief. And now the state of Ohio also considering one. We'll talk to the author of that bill in about 15 minutes. State Rep John Becker will be on our show. Constitutional attorney Byron Henry joining us now to talk about the North Carolina response to the DOJ. Byron, good afternoon.
Great to be with you, Scott.
Now, can you explain what North Carolina's law simply says?
Well, first of all, there's a number of components of North Carolina's law. It had to do with cities setting minimum wage and cities passing their own laws with respect to bathrooms and other discrimination ordinances. But the bulk of what the Justice Department has a problem with is a simple provision that says all public bathrooms, and by public I don't mean like public bathrooms in private businesses, but public meaning government, universities, rest stops, as you mentioned, government buildings, schools, all public restrooms and public buildings need to be designated for use by men and women, and by men and women, they simply defined it as biological gender at birth. And so what we've had for at least all of my life, men's and women's restrooms with men using men's restrooms and women using women, is now enshrined in North Carolina law, and the Justice Department says that violates the Civil Rights Act from the mid-'60s.
And what the question is for people who identify with a different gender other than what is on their birth certificate, whether they've gone through a transformation process, whether they've had the surgery or not.
That's correct. And in fact, North Carolina actually allows a person to have their birth certificate amended to reflect their current gender if they've gone through some sort of process of altering their gender. So that really isn't an issue under the law. What you did mention that is an issue is this gender identity, which both the law and the parties, I'm not sure, have put their finger on exactly what that means, but it means someone who either feels like, believes, or it has some sort of, cognizant feeling that they are of a different gender than their biology. And so that's still to be worked out. But I believe that's the main issue, is this gender identity issue, not transgenders as we would have thought of them traditionally as someone who's either had a sex change operation or gone through hormone therapy to actually change gender, so to speak.
A pre-op transgender or someone who identifies as the opposite sex wouldn't be able to use the restroom. That doesn't correlate with what's on their birth certificate. This is North Carolina House Bill 2 that we're talking about. What does the Department of Justice say this bill violates with regards to the Civil Rights Act?
Well, it's difficult to put my finger on it right now. It sounds like they are equating discrimination on the basis of sex, which the court means gender. The courts have said means gender in the Civil Rights Act, with discrimination based on someone believing that they are a different gender than what they actually are, meaning if you believe or identify with a female and you have biological male physiology, you want to use the female restroom, but you're discriminating them based on the fact that they identify with a different gender than they actually are biologically. Courts have said up until now that the Civil Rights Act generally, most courts that is, does not apply to gender identity, transgender, or sexual orientation, that that's something the legislature or the Congress would need to take up and amend. But this new lawsuit will put that to the test once again.
Well, and that's kind of what the governor of North Carolina, Pat McCrory, has said. The Department of Justice gave the state until today to respond to their Civil Rights Act complaint, and the response from the state of North Carolina has been to essentially sue the DOJ and say, hey, somebody needs to clarify what the definition is, and in the meantime, we need injunctive relief. Am I correct in interpreting what that suit is?
Yes, that's exactly correct. Just basically, you can't take any action on us based on this law until a court actually determines that we are actually violating the law, not a representative of President Obama's Justice Department, but in fact the court determines that there's been a violation of the law, you can't take any adverse action against the state.
Is this something that a court will need to clarify all the way up to the Supreme Court, or is this something that would be clarified through legislation?
Well, certainly if Congress were to amend the Civil Rights Act and change the law to protect sexual orientation or transgender or gender identity, that would settle the issue. But short of that, you'll have to have a court, possibly all the way to the Supreme Court of the United States, determine if the word sex in the Civil Rights Act from the mid-'60s applies to transgender or gender identity.
Is that an overreach of the Obama administration to try to get North Carolina to comply? Is that what part of the issue is?
Well, to put it kindly, it is a stretch to argue, especially in the face of a decade of argument that the Civil Rights Act needs to be amended because it does not cover transgender or gender identity or sexual orientation, to now say that a mid-'60s law, which actually contains a provision in it that deals with separate locker rooms and restrooms for men and women, and that is not discrimination, all of a sudden in 2016 we discover, in fact, that the Civil Rights Act covered this. So it is certainly a stretch, like the immigration rules. Generally, the Obama administration, when it cannot get what it wants passed through Congress, a lot of presidents have to either make deals or compromise. This administration seems to just, by fiat, issue executive orders or a letter from the Justice Department saying, we believe you're violating the law, and it looks like a court's going to be the ultimate arbiter of whether that's the case, just as in the immigration context.
It seems to me, though, a lot of this is a solution in search of a problem.
Certainly, and the problem here is that one thing the governor, I think, has mentioned, at least on the talk show circuit and the news shows, is that there's not even an enforcement provision in place, and no individual has actually been harmed yet. No one has been discriminated against. We don't even know how this law is going to work in practice with respect to whether people are going to be arrested or cited for using the wrong restroom. So it's a bit premature, as you put it. And remember, the Civil Rights Act doesn't mention bathrooms. It's just a generic, you can't discriminate based on sex. And if gender identity and transgender is included in sex, that applies to all areas that the Civil Rights Act applies to. Sports teams, dorm rooms, everywhere there is a distinction between male and female in government or in universities' life would be suspect under the Justice Department's interpretation of the word sex in the Civil Rights Act.
Well, we'll see what is possibly in store for the state of Ohio, where there is a piece of legislation being authored now, and we'll talk to State Rep John Becker about that next. Byron Henry, constitutional scholar in Dallas. We appreciate your time as always.
Thank you.
It's 3:29 on News Radio 1370.